Yes.
My Lord, my Lady, before lunch I was just addressing the rules of the scheme. I just want to finish doing that very briefly, if I might. I now want to turn to Rule 6, which is on page 54 of the supplemental bundle.
Yes.
And those are what are colloquially referred to as the good leaver, bad leaver rules, although of course they don't use that terminology expressly.
Sorry, I didn't catch what you said they were called.
Colloquially, they've been referred to as the good leaver, bad leaver.
Oh yes, yes.
That's common terminology in this sort of scenario. The rules don't use those words expressly,
Understandably.
but in essence, that's what they are. One looks at 6.1. The rule is that the general rule is that an award which is not vested will lapse when the employee ceases to be in employment. So an award that has vested will not lapse, but where the award has not yet vested, it will lapse. So if you leave employment, you lose your unvested awards. That's the default position. 6.2, my lords, my lady, then provides an exception to that. It's headed leaving in exceptional circumstances unvested awards, and it provides that where a participant ceases to be an employee of any member of the group for any of the reasons set out below, then his awards which have not vested will vest as described in Rule 6.3 and lapse as to the balance, and then it gives various reasons: ill health,
Yes.
divestiture of the relevant company, transfer of undertaking, redundancy, retirement, or any other reason.
And in this case, the appellant?
Well, in this case, that would it would be retirement with the agreement of the company.
Yes, so the appellant falls into that category.
The appellant falls into
Under
that
6.2.
category. Under 6.2.1, little retirement with the agreement of the company, indeed. So the company is the group company. Yeah. And that was provided for in the retirement agreement. We can turn it up if necessary, but your my lords, my lady will have noted from the retirement agreement that although that agreement was with Health entered into that agreement as agent for all other companies in the group.
Yes.
So rather reverse of the position that is advanced in this case, where it is said that group is the agent and Health was the principal. In fact, when there was an express contractual relationship,
Other way around.
it was the other way around.
Okay.
Which is the more natural way. But the principal point for current purposes is the overwhelming majority of these reasons for being a good leaver, to use the colloquial terminology, are reasons that are within the control of the company, the group company, or the group as a whole. So, for example, putting aside ill health, which obviously is not within the control of the company, save that it has to be established to the satisfaction of Group Co. The others, the divestiture of the business, well, obviously that's something that Group Co can determine. Transfer of an undertaking, obviously that will be determined by Group Co. Redundancy, that will be determined by the employing entity. Retirement with the agreement of the company or Group Co, or any other reason determined by the remuneration committee rather of the company. So those are the provisions under Rule 6. And then Rule 6.3, I'm not going to read out the entirety of those because they're
performance conditions.
It relates to the performance conditions, yes, and it provides that they'll be assessed as at the end of the financial year,
yes,
in relation to which the employee leaves, and they provide that the employee will get a pro rata sum depending on how much of the performance period they remained in employment, and the rest will be lost. So those are the, I say again, use the colloquial terminology, the good leaver, bad leaver provisions. And then the final point that I want to make under the rules is to take my lords, my lady, to Rule 11. That is on page 59 and is headed Terms of Employment. and it provides 11.1 for the purpose of this rule, employee means any employee of a member of the group, so that reflects the position under Rule 1. 11.3, nothing in the rules or the operation of the plan being the rules, forms part of the contract of employment of an employee. The rights and obligations arising from the employment relationship between the employee and the company are separate from and are not affected by the plan. Participation in the plan does not create any right to or expectation of continued employment. And then 11.4, no employee has a right to participate in the plan. Participation in the plan or the grant of awards on a particular basis in any year does not create any right to or expectation of participation in the plan or the grant of awards on the same basis or at all in any future year. So plain as a pikestaff in the rules, in the plan, these are separate to the contract of employment. They do not form part of it.
Could they be overridden by the contract of employment?
Well, my lord,
at least theoretically.
no, because the contract of employment, the group co is not a party to the contract of
No.
employment. It is the only way, and I'll come on to deal with the contract in a moment, but ironically, the only way that the contract of employment could ever be said to bind group is if it was said that health entered into the contract as agent for group. And of course, that is the reverse of the contention that is made against me in these proceedings. So no, the contract of employment does not bind group. It cannot bind group because of the doctrine of privity. Even if one looks at the statutory reform to the rules on privity, they only extend to in relation to benefits, not burdens. So there is no way that the contract can bind a group. What does bind group and what authorises group to act in this case are these rules. And that in essence is and has always been the core of our submission in these proceedings. The authority arises from the rules. It is authority granted to group, to the remuneration committee, and there is no need to find any sort of agency relationship. Indeed, the existence of these rules and the fact that the authority derives from them drive a coach and horses really through the argument as to agency.
On agency.
Yes, on agency.
Yes.
So those are the factual positions I wanted to take you to in relation to the rules. Just to finish off my summary of the facts, if I might, and then I'll move on to the agency argument in a bit more detail. The common ground that what happened in this case was that the performance period was 2017 through to 2019. The performance conditions on an earnings per share basis were not going to be met, and therefore the awards were not going to pay out. And the awards in this case are made to the very most senior managers in the business. So there was a concern that if these awards did not pay out, that would lead to a retention.
Exodus.
Exactly. It would lead to an exodus. And that came at a particularly difficult time for the group. Why so? For two reasons. First of all, as you, my lords, my lady, will have seen from the tribunal's judgment, there was a change of chief executive at around this time. The new chief executive came into post, I think, in September of 2019. And secondly, the new chief executive was in the process of considering a restructure, which was referred to before the tribunal as RB 2.0. So there was going to be the possibility of restructuring. As it is obvious, restructuring can involve the possibility of people's jobs being lost. And with all that uncertainty,
As to the risk of exodus.
that's the risk of exodus, indeed. And just to make point that that point, if one turns up the tribunal's judgment, this is in the core bundle at page 112. This might have a
This is dealt with in some detail in the statement of Ms. Harris.
yes, indeed.
You put what some may call a diplomatic gloss on it, but there's a little bit more as well, and that is in her statement.
Yes, my lady, that's correct. There is a good deal of detail in the same. But I'm summarising the position, and I'm about to take the court to the tribunal's summary of it. But the crux of it is I hope I've summarised fairly. and that is there were very, very significant concerns about retention arising from those factors. And we'll see those if we turn to 112. And my lady's absolutely right, and of course I can see you've already read that statement, but whilst you deliberate, I'd encourage you to read it again. It sets out the concerns in a good deal of detail. And of course the tribunal heard from Ms Harris in some detail. She gave live evidence in the proceedings. But at 194, we see the tribunal's summary. And just picking it up 4 lines down, the tribunal says, we note there were several factors that had come together that would give rise to significant concerns about retention. In the first place, the LTIP scheme, which had previously given full awards, was no longer going to do so. Beyond that, there were the twin uncertainties of what was to occur with RB 2.0, whether the business would be fully split into 2, and the introduction of a new chief executive. These uncertainties would be particularly felt at the most senior end of the business, the T40 and the T400. That's the top 40 and the top 400. And 400 may seem like a lot, but obviously we're dealing here with a very large global group. So these are the most senior managers in the business, where individuals would be bound to be concerned about their roles within any redesigned business and or what view the new chief executive would take of their part in the business and their role within it. We also note, of course, the primary purpose of any retention measures would be to prevent a retention problem arising, not to try to recover the situation or the problems arisen. Those who have left cannot be retained by retention measures implemented after they have left. It is proper to put in place measures ahead of an anticipation of a retention problem, not to wait until a retention problem is demonstrably occurring before taking measures. So there the tribunal summarises the problem and the solution to the problem that the group code fashioned was to permit the awards to vest at 50%, irrespective of performance. There still remained a stepped set of tiers, if you like. And I'll take the court in a moment to the relevant document. But from zero, earnings per share growth from 0% through until 7.5%, I think it was, the awards would vest at 50%. So whereas under the original performance conditions, nothing would vest, employees would get 50%, but they would only get 50% if they stayed in employment through until May, because it was only if they stayed in employment through until May that the awards would vest. Subject, obviously, to the good leaver, bad leaver provisions. Again, I use the colloquial terminology, which I'll come on to in due course. So, within that, well, I should just take my lords and my lady to the relevant document. That's a supplemental bundle, page 98. These are the minutes of the meeting. I'm sure we'll look at these already. But these are the minutes of the meeting held in Boston on the 18th of September 2019. And one can see, I hope, the table at the bottom of the page, and that's under the terminology, after due and careful consideration, it was accordingly resolved that, and it was provided that the rules would be changed, the performance targets and vesting schedule would be changed. So whereas previously in the table, one can see on the left-hand side, if the 3-year earnings per share compound growth was less than 6%, you get nothing. The new provision was that if it was below 7.5%, so 0 to 7.5%, 50% vested. And the reasons why that was done, as I say, were to provide for a period of certainty in the business through until May of the following year, in order that the chief executive could be bedded in his new role and work out what he wanted to do with RB 2.0. They needed the top team to stay in place over that period of time. And therefore they fashioned rules, changes to the performance conditions to encourage the top managers to stay through until May. And it stands to reason we say that if what you're trying to do is to encourage employees to remain in post, that is a benefit which you should only extend to existing employees and not provide it to those who have already left, because you cannot encourage those who've left to stay in post, self-evidently. And the tribunal made exactly this point, and this is a paragraph that I'll come back to in due course, but you've still got, my lords, my lady, page 112 open.
Yes.
And then the following paragraph, 195, this is where it's dealing, this is under the tribunal's heading, retention as a legitimate aim. They make the point that it wasn't necessary to consider any quantitative analysis, and they go on to say retention was the essence of the PCP. Putting it bluntly, individuals were getting valuable awards they would not otherwise be entitled to, and in return, they were doing nothing more than remaining within the business for a particular period of time. The obligation to remain within the business for a particular period of time was reinforced by the extension of vesting to May 2020. That the amended performance condition only applied to those who were employed at 18th of September 2019 was entirely consistent with that. Those who'd already left the business could not be retained. And then it goes on to talk about the 6, and I'll come back to those in due course. So the Employment Tribunal, when it made its determination, accepted our case that this was a retention measure, and as part and parcel of the retention measure, it was directed towards those employees who could be retained, and it was not directed towards those employees who'd left, because frankly, and I use the term in the colloquial terminology that's used in some of the cases, if you were to extend it to those who'd already left, A, it's not a retention measure, and B, they're just getting a windfall. And that is our case. So that's my summary of the factual position. I'll now move on to deal with the agency point in a bit more detail, and I'll do that under 2 heads. First, relevant law, and second, why the ET was wrong and the EAT correct. So dealing then with the legal position, the starting point obviously is the Equality Act, and in particular Part 5 of the Equality Act and Section 39, which provides that, we can turn it up,
Yes.
my lords, it would be helpful.
Maybe that would be helpful for me.
My lords, maybe yes. So it's at page 213 of the bundle. So you'll see at the heading Part 5, Work, Chapter 1, Employment, etc. And then Employees is the subheading, and 39.1, an employer A must not discriminate against a person B, and there are various circumstances. And then subsection 2, an employer A must not discriminate against an employee of A's B as to the terms of employment, and 2D is the one that's usually relied on, so by subjecting B to any other detriment. So the principle, the governing criterion of discrimination law is it's the employer who must not discriminate. That's the gateway in Part 5 of the Act. Now, it is true that there is an extension of those provisions in some respects found in Part 8 of the Equality Act. And we see the relevant provisions at Part 8 from 216, page 216 onwards. And sections 109 and...
Before we leave that,
yes.
If somebody was in employment, because obviously we are going to be concerned that the Act was intended to prohibit discrimination, if somebody was in employment with the health group, and the health group said, you will have benefits determined by somebody else, and it turns out that somebody else had calculated the benefits in a discriminatory fashion, the employer would still fall within 39.2, wouldn't he? He'd still be liable. It wasn't his fault that the terms are discriminatory, but if they are discriminatory, then he's liable for it. You don't need to get into agency during the terms of the employment, do you?
It depends on the factual scenario. Taking up the factual scenario that my lord put to Mr. Reid earlier, if the employer says, we are going to, I can't remember it was the Midland
Midland
Bus
Bus.
Company.
I don't know why I said Midland Bus.
I don't know why you said the Midland. I mean, I think Midland must have had an unhappy experience in Wolverhampton some years ago, but there we are.
Well, there it is. Whichever bus company in whichever part of the country, whichever set of terms and conditions one is involved with, if the employer says we are going to adopt those terms and conditions, I mean that's essentially a corporation by reference, and so yes, the effect of that would be, if one looks at 39(2)(a), the employer would be discriminating as to the terms of the employment. That's exactly right.
Yes.
However, if what the employer says in a contract is something to the effect of, is to note the existence of a separate set of benefits which are provided independently by another company pursuant to separate contractual relationships between the employee and that company, then that would not engage Section 39.
Well, we're going to come on to presumably clause 5 of the contract in due course.
We will, of course.
When you've taken your run up at it.
But the example I gave in my skeleton argument, which Mr. Reid adopted to some extent, is the gym. If the employer in the contract says we've negotiated preferential membership terms for a gym, so you get 20% discount, say, and then the employee goes to the gym and says, well, I'm an employee of a company, and therefore I want to have 20% discount, and the gym then enters into a separate contract with the employee, well, that's nothing to do with the employer. And indeed, it could not be said that the gym was acting as agent of the employer. The gym is acting as a contracting party itself. It is entering into a contractual relationship with the employee. That is the distinction. And I will come on to say that's the situation here, in essence, because what is happening here is that Group is not acting as agent of health. Rather, it is creating a separate relationship, a separate legal relationship between itself and Mr. Fasano, the claimant, in this case. That's what's going on here. And I will say, I'll come on to explain how that works.
Well, you'll show us what you mean by that in due course.
Yes,
so you want to take us to...
so where I got to, just to sort of
Part
say
8.
again, 39 is the governing criterion under Part 5. Then there are a separate set of ancillary provisions. And indeed, if one looks at 216, that is what Part 8 is headed, prohibited conduct ancillary. And 109 and 110, they really operate in tandem to do two things. What 109 does is it says that employers will be liable for the acts of their agents. In fact, it goes a bit further than common law vicarious liability. It says that employers are treated as having done the acts of their employees. And it says that principals will be treated as having done the acts of their agents, provided that those acts are done with the authority of the principal. So it's akin to vicarious liability. It's not quite the same as vicarious liability, but it's akin to vicarious liability. And then 110, which is at 218, then places the liability, it's a joint and several liability, but places liability on employees or agents where they have done the act that the employer or principal is vicariously liable for. So section 110(1), a person A contravenes this section if he's an employee or agent. He does something which by virtue of section 109, 1 or 2 is treated as having been done by A's employer or principal, and the doing of that thing by A amounts to a contravention of this act. So the provisions in tandem, summarising them briefly, are the employer has the principal liability. If an agent of the employer does something, then the employer is vicariously liable. I'm using vicariously liable in general terms. It's not vicarious liability, but it's just an easy shorthand. The employer is then vicariously liable for the act under 109, and under 110, the agent is
as well,
also liable. So that's the scheme. but the scheme of liability hinges on the employer being liable in the first place under Section 39. So that's the scheme, and that of course then raises the question when one is talking about agents and principals, well, what is meant by that? And the other side's case on this is a little bit confusing. I hope my case is clear. It is clear, I say, from three authorities, Kamei, Blackwood, thank you, my lord, and Nailard, that what is at issue here is the common law definition of agency. And I hope I can make that good quickly. It is true to say that there was a little bit of disagreement or a little bit of uncertainty in Kamei, but that has been long since put to bed, if I can use colloquial terminology. So if one looks at Kamei, that's at tab 8 of the. I can't remember whether
You have tabs in this.
You have tabs. I'm grateful.
In the authorities bundle.
So tab 8 is Kamei, and let me just take you through the couple of paragraphs that I hope will explain the position. Lord Justice Elias gave a judgment, and at 146, paragraph 46, after some discussion, I should say, my lords, my lady, I will be coming back to this case and I will deal with the facts in a little bit of detail in due course, because I think that it is helpful, but I just want to make this point about the relevant test, if I might first. So 46, Lord Justice Elias's conclusion after some discussion about the scope of agency says, for these reasons, therefore this appeal must fail. Whatever the precise scope of the agency concept in section 32, that was a similar provision in predecessor legislation. And in my view, it must at least reflect the essence of the legal concept. Ms. Ursher does not fall within it. So that was Lord Justice Elias. Lord Justice Lewison was unequivocal, page 150, para 70. And he said, under section 32.2, Parliament has chosen to attribute liability by reference to well-established legal concepts. It must therefore be taken to have intended those legal concepts to be interpreted in accordance with ordinary legal parlance. And he then went on to refer to a case called Yearwood, which again I'll come back to, which had made this point. So that was Lord Justice Lewison. And then, as my learned friend Mr. Reid indicated, Lord Justice Kitchen at page 151 agreed with both judgments.
Section 32, we see quoted, set out at paragraph 9 of Lord Justice Elias's judgment. And that's just the predecessors of 109 and 110, is it?
Yes, exactly right. So that is
it's all wrapped up in one section.
What the position was before the Equality Act, my lord, rather unhelpfully, there was a suite of legislation. There was the Race Relations Act.
Yes.
There was the Sex Discrimination Act. That for each different ground of discrimination, the Equality Act consolidated that. The 76 Act is the Race Relations Act.
Thank you.
But they contain provisions that were pretty much the same.
Okay.
So that's Kamei.
And Lord Justice Kitchen agree with both.
Agree with both. Now, make of that what you will.
But
What then happens is we move on to Blackwood, and this was a judgment given by Lord Justice Underhill, and happily the Court of Appeal was in agreement on this case.
including Lord Justice Lewison.
Including Lord Justice Lewison, indeed, my lord. But if one turns to page 171, paragraph 57.
Well, just look at the facts. I'm not familiar with this. She was a university student.
Yeah.
She took a placement with the trust.
She took a placement.
By the university as part of her diploma.
Yes.
And she made a claim against the trust. Was she saying the trust was the agent then?
Yeah. Trust is the argument. It's a work
the agent
placement.
of the university.
Exactly.
The way they dealt with her on the placement.
Exactly.
Okay, thank you. Sorry. Yes.
And 57, and I'll come on to the facts again in a little bit, because again it's instructive as to the analysis in this case. But at 57, well though Mr. Pepperell developed the point, I'm not persuaded that the approach represents a possible construction of the Act. It is settled law that references to agency concepts in this legislation are to be given their ordinary common law meaning. Ministry of Defence and Kamei, and the judgment, as is the case with Lord Justice Underhill's judgments contain some footnotes, and 3 then makes reference to the decision in Kamei being under the Race Relations Act, but notes that the provisions are substantially identical. And he refers then to paragraph 70. And that's agreed with all the judges. So whatever scope there was for argument as to what the position was in Kamei, the interpretation of Kamei has been settled by Blackwood in a unanimous judgment of the court. And then one takes it on further into Nailard, and there is some suggestion in my learned friend Skirton argument that the position in Nailard muddies the waters somewhat. It doesn't in the slightest. The principal point that was at issue in Nailard was the extent to which agents could be liable under the Equality Act, or the extent to which principals were liable for their agents' acts. And the court concluded that essentially the position that should be adopted was the same as in relation to employees. So employees are liable under the Act, or rather employers are liable for the acts of their employees, where the employee commits a discriminatory act in the course of their employment. And essentially the court said the same is true of agents. The principal is liable for the acts of the agents where the act occurs in the scope of the agency. We can see that at paragraph 42. So the starting point is a statement of Lord Justice Elias in Ministry of Defence in Kamei, that para 11, that the effect of what is now section 109.2 is that the principal will be liable wherever the agent discriminates in the course of carrying out the functions he's authorised to do. But then jump down the paragraph to the parentheses at letter F. This approach is not, of course, in any way inconsistent with the court's insistence that the terms agent and authority should be construed in accordance with ordinary legal parlance. That point was being made in response to the argument about whether Miss Osher was the MOD's agent at all, not to the question of whether it would be liable for her acts if she were aware. So 3 Court of Appeal authorities, all of which find that it's the common law definition, and to the extent there was any argument in Kamei, there was any difference between the position of Lord Justice Lewis and Lord Justice Elias, that's long since passed into legal history. The position now is clear.
What is meant by the bit above? It may well extend the scope of the liability beyond what we require common law. What's that all about?
Oh, that's about the distinguishing between the position under the Act and the vicarious liability provisions.
Oh, I see, right. Oh, I see, so it's just that they are liable, not they are vicariously liable. Okay, sorry.
Yes. I mean, there are differences in the scope of the. So the Act, for example, says that the employer is liable for the employee's act. It's treated as having done the acts rather than being.
Is the same. The label you attach to the legal consequences thereof is different.
Yes.
Yeah, sorry, my fault.
So that's what we get to on the 3 authorities, and so therefore I submit on behalf of my clients that in order to bring this case within the scope of sections 109 and 110 of the Equality Act, what had to be shown and has to be shown is that Group was acting as agent of Health. Health was the principal, Group was the agent, within the meaning of those terms at common law. Now, what then is the position at common law? Well, the court has the passages from Bousted, and time doesn't permit me to go through those in detail, but I've set out some of them in my Skirton argument. But I want to just dwell on one point, which really is the essence of the EAT's decision. And I would summarise that as this, and one sees this in various of the authorities. Where a person, a legal person, does an act pursuant to authority which is independently granted to that person, it is not acting as agent of a principal. And that perhaps ought not to be terribly surprising, because the doctrine of agency is based on authority. The principal gives the agent authority to act, and that is why the agent can act, because it's granted the authority to do so. So if one takes the classic case of, for example, a solicitor signing a contract on behalf of a client, the solicitor there is acting as agent for the client. the only basis that the solicitor has to do that, the only authority that the solicitor has to do that, is because it's granted the authority to do that by the client. Otherwise, it cannot do that. It cannot enter into that contract on the client's behalf. It cannot bind the client in contract. It is the authority that comes from the principal to the agent. Where the authority comes from another source, that is not an agency relationship. And we can see that in some of the authorities. And so if one, and I'm sorry to take my lords and my lady through the same authorities again, but I'm just making, I hope it's understood making a slightly different point, and it's helpful to do it thematically rather than to go through each authority one by one. But if one looks at Claimant, so this is tab 8 again, and just to summarise the facts of Claimant, in the Claimant, the claimant was a soldier. Soldier alleged that he'd been racially abused by an employee of Sodexo, which was a third-party company. Sodexo provided mess services to the MOD. So the relevant employee is working in the canteen. The soldier asked the employee to do something, and it was alleged to have been racially abused in response. And the court found that there could be no liability in this scenario. And it found that on the basis that the employee working in the mess was not acting as agent of the MOD. On the contrary, the authority for the employee to be in the mess and working in the mess arose from the employment contract with Sodexo. So the authority comes from a separate source, namely the employment contract, and therefore there is no agency relationship. Now, just to make that point good, I will take, if I may, the court through a couple of passages, but I'm going to start by taking my lords and my lady to paragraph 34 of the judgment. And in this part of the judgment, Lord Justice Elias is dealing with a previous case called Yearwood. And let me just summarise the facts of that before I delve in. You've not got the report in the bundle, but this summary suffices. Yearwood is a case, there is a particular oddity in the legislation because police officers are not employees, they are officers. Therefore, they don't naturally form within the scheme of the legislation. They are treated as employees of the chief constable for the purposes of establishing liability in some scenarios. But of course, because they are not employees in the ordinary sense, they're officers, there is a difficulty with the vicarious liability provisions. So the argument in Yearwood, what had happened in Yearwood was the chief constable had appointed investigating and disciplinary officers. And the argument was, when the chief constable appointed the investigating and disciplinary officers, those were agents of the chief constable, and therefore, if they discriminated against an individual in the course of their functions, the chief constable would be liable vicariously for those acts. Not so, said the EAT, no agency relationship. And just looking at what Lord Justice Elias says at paragraph 34, I would respectfully agree with the conclusion of the Appeal Tribunal in Yearwood that there was no agency relationship between the chief constable and the disciplining and investigating officers. But I do not think that this conclusion turned on the particular concept of agency employed. The result would, in my view, have been the same even if the appellant's concept had been adopted. The officers were independently exercising an authority conferred by the regulations. The chief constable chose them for the task, but he was not thereafter the source of their authority. Could not sensibly be inferred in the face of the regulations that the disciplinary officers were exercising their powers by virtue of any authority conferred by the chief constable. No implied authority from the chief constable was needed to explain why they had the power they did. So they get their authority because the disciplinary procedures in relation to police officers are governed by statutory instrument. Although the investigating officer and disciplinary officer are appointed by the chief constable, once they're appointed, the source of their authority comes from the regulations. It comes from an independent source, and that is wholly contrary to the concept of agency. The power comes from that source. Now, same point is made in the context of the facts of this case. If we jump forward to paragraph 41, and here Lord Justice Elias deals with the Sodexo MOD situation, in my judgment, Ms. Usher's contract with Sodexo, so Ms. Usher is the person who was alleged to have made the racially abusive remarks. In my judgment, Ms. Usher's contract with Sodexo is the source of any authority she has to make decisions relating to the butcher's department in the mess. It may be, as Ms. Romney asserts, that ultimately the MOD would have the right to veto her presence, at least for good reason. But that limited degree of control comes nowhere near constituting an authorisation by the MOD to allow Ms. Usher to act on its behalf with respect to third parties. So again, where does the authority come from? In relation to the mess worker, the authority comes from their employment contract with Sodexo. No agency relationship with the MOD. You don't need to imply one, there's no express one, because the authority comes from a separate source, namely the mess worker's contract with Sodexo. And so it goes on when one turns forward to para 43 in the judgment of Lord Justice Elias. Here, Lord Justice Elias is dealing with the situation where, where there are different group companies. He says, I would respectfully agree that the fact that someone is employed by A would not automatically prevent him from being an agent of B. And I would not discount the possibility that the two relationships can coexist even in relationship to the same transaction. But in my judgment, there would, particularly in the latter case, need to be very cogent evidence to show that the duties which an employee was obliged to do as the employee of A were also being performed as an agent of B. It is in general difficult to see why B would either want or need to enter into the agency relationship. That is so whichever concept of agency is employed. There is a complete lack of such cogent evidence here. So if you've got an employee, true it is, they may simultaneously act as an agent for another company. That is possible. For example, you may have a group company that says, we expressly authorised you to enter into a contract on our behalf, to sign this contract. That may be an example. But in the ordinary course of events, absent the very cogent evidence, the source of the authority for the employee to undertake their acts is clear. It comes from the contract of employment, and there's no need to employ any agency analysis. So that's Kamei. When one turns to Blackwood, and again, I'm turning now tab 9, page 171. And I'm going to pick up the case at the bottom of the page, 3 lines up from the bottom, although I do not rule out. I don't know whether the course is, I'll just pause while the course.
No, yes, we were there a moment ago, weren't we?
Yeah, and I am sorry to jump about.
Well, though, Mr. Pepperell developed the point paragraph.
Yes, exactly. So I took you to the opening part of the paragraph, and now I'm going to take you to the finding of
conclusions.
facts. Exactly. Yes. Although I do not rule out the possibility that there may be some kinds of arrangement between a university and a provider of work placements under which the provider acts as agent for the university, it is inconceivable that this with university be the case, still less that every act of the provider can be done with the authority of the university. On the contrary, in the case of a typical student work placement, say with a school or hospital, while the university will no doubt have agreed certain parameters with the provider about what work will be provided, it will in the nature of things have no involvement in or no control over the student's day-to-day working environment. It's hard to see any basis for characterising such a relationship as one of principal and agent, as opposed to an arm's length relationship between the two principals, and harder still as one where every act of the provider is to be treated as done with the authority of the university.
Is there any difference in a situation where you have a group of companies, as you do here?
No, and indeed there is a passage in Bousted. I can take my lord to the passages at para 30 of the section in Bousted that we've quoted, which says there is no concept of group agency known to the law. An agency, as between group companies, has to be established on ordinary principles.
Yes, but might it not be easier, to pick up Lord Justice Underhill's phrase, might it not be more likely for there to be the possibility of that sort of arrangement of agency in a group of companies than in this sort of obviously arm's length situation that arises both in Blackwood and Kamei?
Well, it's difficult to see why, because it comes back to the question of corporate personality. There are separate companies. Those separate companies are entering into separate commercial arrangements or separate contractual arrangements. Why is there any need to make any finding of agency in that context if the contractual relationships that are entered into adequately explain the position?
It's also odd to see why the subsidiary, which is owned by somebody, should be the principal.
Indeed.
I know the Pope on the analysis that Mr. Reid gave can employ or hire the bellboy, but very often he doesn't.
Well, that is exactly right. It is very difficult to, it is not impossible to envisage a situation where a top co, holding co, parent co could be an agent. There may be a situation where, for example, the subsidiary says, please enter into this contract on our behalf. But the ordinary course of events is obviously a situation where the parent company controls the subsidiaries, particularly a situation where they're 100% wholly owned subsidiaries, particularly in a situation where the subsidiary is well down the chain. And it is therefore very difficult to see why there should be any relationship of agency there, and how, in general terms, any relationship of agency could arise in circumstances where the subsidiary cannot control the parent in any sense whatsoever, or indeed even act so as to bring an end to the agency relationship. And I'll come on to develop that point in due course. But just going back to Blackwood for a moment, the point here that's being made by Lord Justice Underhill is that in the context of a university and work placement scenario, the student and the provider of the work placement are entering into an independent contractual relationship. There is no reason or no need to identify any sort of agency relationship there in circumstances where the parties are entering into contractual relationships themselves. And the same is true. I'll take you to one more authority, if I might. It's a decision of the House of Lords, an old decision that Millennium Friends rely on. They rely on it broadly, I think, to make the point that agency is about consent, referring to the dissenting judgment of Lord Wilberforce. Turning to the majority decision in that case, it's actually rather helpful to my position and not theirs. It's a tab one of the bundle of authorities, and if I could just sketch out the facts. What happened in this case, this is a hire purchase situation. So you've got a dealership selling a car to an individual. And as is often the case, cars are bought on hire purchase arrangements, and therefore there are arrangements with the finance company.
Yes.
The dealer provides the hire purchase company's forms to the customer and fills them out with the customer, and then it's sent off to the hire purchase company to ultimately approve. Now, what happened in this case? This is a fraud case, so the forms were with the effect that the customer was said to have incurred a very large liability to purchase a rapier, I think it was, far in excess of what had been agreed. And the question, therefore, was whether or not the dealer was acting as agent for the finance company in the course of the transaction because they wanted to fix the dealer with liability. So those are the facts of the case. Now, Lord Upjohn gave the speech, or one of the speeches that was in the majority. One turns to page 27 of the bundle. He sets out a passage from Mercantile Credit and Hamblin, which he says stated the law correctly, and this was accepted by the majority. And he quotes this passage: "There is no rule of law." So it's at A to C of page 27. "There is no rule of law that in a hire purchase transaction the dealer never is or always is acting as agent for the finance company or as agent for the customer. In a typical hire purchase transaction, the dealer is a party in his own right, selling his car to the finance company, and he is acting primarily on his own behalf and not as general agent for either of the two parties. There is no need to attribute to him an agency in order to account for participation in the transaction." He goes on to say there may be some circumstances where there is a limited agency. And if one then picks it up at page 29, dealing with the learned judge's analysis of this case, and I'm going to pick it up at letter D, passage: "I cannot see how, in fact, it's possible to spare out of this transaction that in these circumstances the dealer is in any way a general agent for the finance company. He is a principal acting on his own behalf in selling his own car, in taking at a price another car in part exchange, and in submitting the hire purchase forms to the finance company, submitting them as proposals on behalf of the would-be hire purchaser. That is good business on his part. No doubt when the transaction has gone through and the hire purchase agreement has been completed, the dealer has the express authority of the finance company to hand over the car which they purchased the hirer. But on the facts of this case, That seems to me to be the extent of his agency on behalf of the finance company. So what's being said here is that the dealer is not acting as agent when he hands over the finance company's form. The dealer's role in the transaction is in selling the car. He's acting as on his own account. All he's doing is facilitating that by providing the finance company forms, which are signed and then ultimately passed to the finance company. So this is another example of what we see in Blackwood, a rather older example, of a situation where the authority for the individual to act as they are acting comes from a separate source. Here, because the dealer is acting on his own behalf in relation to his own transaction, that is contrary to any sort of situation of agency. So
Lord Wilberforce disagreed, did he?
Lord Wilberforce disagreed.
And Lord Reid agreed with Lord Wilberforce.
Yes, but they were in the minority. They were dissenting judgments. So the majority was Lord Upjohn. His judgment was.
Yes, I know. I'm
Yeah.
Lord Morris gave his own judgment, actually.
Lord Morris gave his own judgment, and indeed
Who at the moment?
there was a final judge that simply agreed with Lord Upjohn. It is. Sorry, my lord, I should have that at my fingertips. It's Lord Guest, 225, Lord Guest.
But it's still 2-2,
yes.
Well, no, because Lord Morris agreed with Lord Upjohn. It gave it his own judgment, but essentially reached the same conclusion as.
And Lord Wilberforce was adopting the view of Lord Denning in an earlier case, was he?
Yes, that's right.
So it's not an area of law where there was unanimity amongst the distinguished lords.
There was not unanimity, but if one looks at the.
You're urging us not to go behind the strict
But
stare decisis.
does this case really help us? Because it's more about the particular facts of that case and whether or not, when you've got a tripartite relationship between a car purchaser, a car seller, and the financing company, are they a threesome or are they all going separately to the party?
It's only helpful in this respect. It is another example of the fact that where somebody is engaging on their own account in relation to a transaction, where they're entering into contractual relationships on their own account, that is not a situation of agency, because of course the fact that the individual is engaging on their own account is an explanation of why they're engaging in the transaction rather than an agency explanation. And so applying that to this situation, what's happening here in our case is that Group is entering into a relationship with Mr. Fasano when it grants the awards. That's the relationship, and it does that pursuant to the authority given to it by the scheme rules. It is not a situation where the authority comes about from a third party, namely Health, providing that authority.
If you look at what Lord Wilberforce said on page 37, don't want to take a time. I think that illustrates the Lord's point, which is that we're quite a long way on the facts of hire purchase contracts, particularly as they existed in the 1960s, which is before even I was driving.
I'm not going to press the point. I only refer to it by way of analogy, and I say it is just provide another example. I don't suggest, of course, the facts are in any way similar to this case.
All right. So that's what you wanted to say on the authorities.
That's what I wanted to say.
And now
on
you're
the
going
authorities.
to say why the EET was wrong. EAT was right.
EAT says it's right.
I'm going to say the EAT is right, the ET was wrong.
ET wrong, EAT right.
That is
I've written down.
That is correct.
That's right.
ET wrong, EAT right.
On this point.
On this point, exactly. And let me just summarise that, the reasons and the nature of my argument before I turn up to the judgments themselves. We say that what the EAT says, the kernel of the EAT's decision, is that there is a complete absence of authority in this situation, moving from Health to Group for the provision of the palliative scheme. And the reason for that is that the authority comes from the scheme rules. We say that analysis finds echoes in the authorities because they are clear that where somebody is acting pursuant to an independent power or on their own account, they're not acting as agent. And one can test the position a little bit pursuant to the facts of this case. Health could not authorise Group to issue shares. The relevant shares are shares in group. Health has no power to cause group to do that. It cannot provide the authority. And moreover, Health could not withdraw the authority. Once an award is issued pursuant to the rules of the scheme, Health cannot turn around and say, well, this was an agency situation, I withdraw my authority. It cannot do that. Once the award is issued, it has been issued and is bound to be dealt with according to its terms. So what is happening here in this situation is Group is creating its own legal relationship with Mr. Fasano, pursuant to the terms of the award and pursuant to the rules of the scheme. It is not altering Health's relationship with Mr. Fasano. It is not causing Mr. Fasano to enter into any relationship with Health. It is not altering that legal relationship.
Mr. Forshaw, I'm probably taking the most simplistic point known, but in many respects it could be said that this begins and ends with the rules.
Yes. But I don't think that is a simplistic analysis. I think that is it.
Yeah.
The authority comes from the rules, therefore no agency relationship. That we say really is the beginning end of it. Now, turning to what the tribunals below decided then.
Yeah.
First to the ET.
We need to deal with Mr. Reed's point that in fact, at 146 and 148, Mr. Reed said the tribunal found as a fact that the second respondent did assent to or author, because that's a fact.
I will deal with that, although I'm not sure one can take it.
Don't overlook that.
Yes, indeed. So if I can start then at page 102. The starting point then at 139 is it is said that the claimant starts from the proposition, so that was Ms. Banerjee below, that a purposive approach is required. And authority for that proposition was a case called Remploy. It's in the bundle of authorities before. I'm not taking to it. It's an unreported EAT decision which predates Kamei, Blackwood, and Maillard.
Does the concept of a purposive approach appear in any subsequent authority or any authority of this court?
Well, on the contrary, in Kamei it is discussed, and the court is clear that one cannot adopt a purposive approach because it's the common law position.
I just think it's slightly more nuanced. In the modern world, you approach the question of interpreting a statute by having regard to the words used in their statutory and general context,
Yes.
and any legitimate aids, and having regard to the purpose of the Act. And the purpose of the Act here is to outlaw discrimination. But once you've done that, that's the meaning of the words. And thereafter, you can't say, I would prefer one of two options, because I think if I were to do that, it would achieve what the legislature was ultimately trying to do, because that isn't permissible. So slightly more nuanced. You do have a purposive approach, but it's looking at the purpose of the Act when deciding what the words mean, not as between different solutions, which one do I think the legislature would like most?
Well, I don't dissent from much of what the law has said. I would put a slight gloss on it, because what and we can turn up the relevant authority, what Lord Justice Elias says in Kamei, drawing on the decision in Riverside, is that he has no difficulty with a purposive approach in general terms being adopted in relation to an Act, provided it's understood what that means.
Yes.
And of course, it's not just what one can't do is look to a purposive approach and say the purpose of this Act is to outlaw discrimination. Therefore, we expand the boundaries of the Act to write out the qualifications and boundaries that are set in place by the Act. And of course, one of the boundaries of the Act is the fact that it doesn't employ generally. The Equality Act does not outlaw discrimination generally. It may be unattractive to discriminate in some contexts, but it's not unlawful to discriminate in contexts. What the Equality Act does, it outlaws it in the employment situation, focusing on the acts of the employer and the employer's employees and agents. So
I don't think it's the matter here, because we've got the Court of Appeal telling us that the words agency are to be used in their normal meaning. And if that means that the group is not an agent, And that's the end of
That's
the
the
matter. The fact that we might prefer, or that even Parliament, if you thought about it now, might prefer bringing them in because they don't want people to be treated badly, is neither here nor there.
No, it's not.
So we don't need to worry about purpose other than that has already been outlined by the law.
Well, we would entirely agree and adopt that position. Unfortunately, the tribunal didn't. What it said...
It was written by Miss Banerjee, you say?
They were. Her compelling advocacy
Which we've
persuaded
not had a
them.
chance to hear this today so far.
One can see that at 142, page 103 of the judgment, and they begin paragraph 142 by saying, "We accept the claimant's argument that a purposive approach is appropriate when considering the question of agency in this context." So they allowed themselves to be led astray and to adopt an approach which, in my respectful submission, is entirely contrary to the authorities. And I did direct the tribunal to the authorities.
I was just reminding myself, was it you against Miss Banerjee?
It was me against Miss Banerjee in the ET and in the EAT. And Mr. Reader's...
Better as you aged is all we can say. But again, they're also dealing with current employees and other employees. There may not be a problem and there may not be discrimination when an employer uses the terms of a parent scheme and that hasn't any discrimination. The oddity here is they haven't relied on the post-discrimination provisions. They've relied on agency for a post-employment scenario. That's the real problem.
Well, I'm not sure that in terms of the Equality Act, I'm not sure the post-employment scenario makes a great difference. It may well make a difference for the reasons that my Lord adumbrates it when one comes to the analysis of agency and justification. But Section 108 it extends the...
Yeah, it would cover an employee, a previous employer giving a bad reference,
Yes.
for example,
Yes.
or saying, I know I've allowed other retired employees to have access to the sports field, but I'm not letting you have access to it because you're black and you don't like black people. That would be out of the window. The thing here is that's not what's being said. What's being said is a different legal entity should be doing something post-employment. So that's why I assume they haven't relied on 108. But this purposive approach isn't necessary to save employees being discriminated against by their employers. That would be Section 39, end of story.
Yes.
It's just a narrow set of circumstances here.
Well, that is absolutely correct. But
The ET reasons for preferring the purposive approach advanced by Ms Banerjee are 142, aren't they?
Yeah.
Well, that's the beginning of it. So they start off by saying they're adopting a purposive approach, and they make reference to, you know, if they were not to do so, the most outrageous discrimination.
Yeah.
I mean, of course, it's entirely erroneous to adopt that sort of analysis because what one is doing is starting from the result and then reasoning backwards, which is exactly what you're not supposed to do. But they then go on to, in essence, find the reasons why they say.
And there's clause 5 sitting.
So they refer to clause 5, and then over the page, they say, 146, reasonably clear that providing the LTIP.
Yeah, here we are. It's 146 and 148.
Yeah, reasonably clear that in providing the LTIP scheme, the first respondent is acting on behalf of the second respondent, providing a benefit. And then at 148, they say, looking at the definition of agency from the first paragraph of Bowson and Reynolds, the second respondent is assented to the first respondent acting on its behalf in the provision of the LTIP. And there appears to be no doubt that the first respondent also assents to acting on its behalf.
Yes,
And
I
that's
picked that phrase up with Mr. Reed.
Yes.
Was it? Well, there was a doubt.
Well, there certainly was a doubt.
Why did the tribunal say there wasn't?
Well, I'm not sure. You'd have to ask them. And indeed, the EAT found that there were simply assertions rather than reasons. And they go, and I'll go on to, I'll come back to deal with the contract point in a moment. But just to finish off reading through the analysis, they also note on the way, because of course one of the crucial parts of an agency relationship is it's fiduciary in nature.
Yeah.
That's clear from the definition in Bowstead.
Yeah.
And they say it is not argued on behalf of the respondents that the relationship, if it exists, is not a fiduciary one.
Well, argue that it's not
that was,
fiduciary.
so they're saying I accepted it was a fiduciary relationship. Well, I didn't accept that.
Well, it was. You didn't argue that it wasn't.
Oh, I absolutely argued it wasn't. I can take you to the passage in my written code if you like. And indeed, in the EAT, Ms. Banerjee rightly accepted that I had. So that is a simple error on the part of the Employment Tribunal. They simply got that wrong.
But breaking each sentence down terribly tediously, what's wrong with the first sentence, if anything, in 146? It is factually correct, isn't it?
It is, well, we would say that what what group is doing is it is providing an LTIP scheme for its own benefit and the benefit of the group. Because of course there are lots of companies in the group, all of whom employ different individuals. And so what it is doing is it's providing it for the benefit of the group and the group's employees. But that's neither here nor there, I say, in the grand scheme of things. There are plenty of relationships where somebody does something for the benefit of another person without there being an agency relationship. The obvious example is subcontracting. If you're in a building, if you're building a big building and there is a chain of contracts, then the ultimate subcontractor right down at the bottom who comes in and, I don't know, fits the doors or something, is doing something for the benefit of Topco, ultimately doing something for the benefit of the customer. They're not in an agency relationship, they're in a subcontracting relationship. And that's why benefit.
If you're a company and you've got a works canteen and you left the subsidiary company's employees use the works canteen, you wouldn't be acting as agent, you would say on behalf of the subsidiary company to make an arrangement to, you simply say, they are allowing a benefit to be taken because they are allowing a benefit to be taken, full stop. It might be altruistic, it might not be, but it's not because they've been asked to do so by the subsidiary company. That's what benefit does not equal agency.
Indeed. And one can test that. Look at Kamei. Miss Aurscher, working in the canteen, is benefiting the MOD by providing food to the soldiers. I mean, she's acting as agent. Look at Blackwood. The work provider is providing a benefit to the university because it's taking on one of their students to provide a work placement. It doesn't mean there's an agency relationship.
What about the first sentence, breaking it down to 148 then? What's your submissions on that? As to why that is not, as Mr. Reid says, a finding of fact, that the second respondent has assented?
Well, there are 2 points I'd make in relation to that. The first is it's not a finding of fact, it is a legal conclusion. It is a statement of their conclusion, it's not a finding of fact.
Is it an assent? Isn't I assent a
No,
fact?
it is, because all assent means in this context, an assent is taken from the definition of agency. All that it means in this context is that the principle authorises the agent to act.
I see. So the facts are, I see, right, okay. And we've covered the next part. Looks as though a material component in the ET's analysis was its observations about the structure of the group. In the middle sentence is in 148.
Yes.
Few direct employees, the entire purpose of the LTIPs, but they've offered by the first respondent to the employees of the subsidiaries.
Well,
those are facts, are they?
those are facts, but those are facts that are, in my submission, largely irrelevant as to whether or not. But the fact that group provides the scheme for the benefit of the employees of the group as a whole is irrelevant to the analysis of whether or not it's acting as agent of the subsidiaries in so doing.
So you were going to say 2 things about the first sentence. I've written down one of them. It's not a finding of fact, it's a statement of legal conclusion. What was your second?
Well, I think I said my second. I should have signposted it, but I'll say it again. My second was that what does assent mean in this context? It means the provision of authority. That's what it means. And here, the authority to make the awards, to amend the performance condition, all of the authority associated with the provision of these awards comes from the rules. Go back to the point that
so they don't identify what fact it is that equals assent stroke authorisation.
Indeed. It is just a general assertion that there's assent here. And really what it comes down to, is what they're really saying here, is that the group provides the scheme for the benefit of all the employees.
Thank you very much. That's helpful. Sorry.
In the provision of the LTIP.
So that is why the tribunal got it wrong. It started off on the wrong foot by adopting a purposive approach. It then did not consider the question of authority adequately or at all. And in so doing, it rested on the assumption that I had made a concession in relation to the fiduciary nature of the relationship, which not only had I not made, I had argued the contrary. So it was wrong for all those reasons. And essentially, that's what the EAT finds, albeit pithily, I think was the phrase used.
If we're going to take anything away from this case, it's going to be that word, isn't it?
Don't use
Well,
the fee word.
Perhaps I should say this, my lady, since you make reference to the word. What is clear from the EAT's judgment is that they did not think that I was pithy. You'll see.
No
from-
one call you pithy, Mr. Fool.
I think the phrase is used that no matter how many times I repeated the
You
submission,
kept on, yes, yes, Groundhog Day, I said earlier.
so I try my best to avoid, but not anyway. There we are.
So
Well,
what would the fiduciary relationship involve? I'm trying to think through. You've got the group and you've got the subsidiary company. If there was a fiduciary relationship between the group as agent and the health company as principal, what kind of obligations would you expect to see enforceable by which of the two parties in a fiduciary relationship that isn't present here?
Well, you'd expect to see, for example, that the group, the essence of a fiduciary relationship is that the fiduciary must act with utmost obedience, if you like, or utmost loyalty. So the utmost good faith, I think, is the phraseology used in the authorities.
So the group would have to act as agent with the utmost good faith to advance the interests of the company, the health company,
Of health company, rather than other companies in the group,
or itself.
or itself. So
so have we dealt with the ET on this point?
we've dealt with the ET.
Do you
If I
like
can
it?
I can deal with the ET quickly. I'll avoid the temptation to say pithily again. Oh, I've just broken that. Page 55, we get the essence of the EAT's reasoning. It's at paragraph 36.
Yes.
And really, my lords, my lady, you've looked at it already this morning. It's the second half of the paragraph. Of most relevance, I can see no basis in the facts found by the tribunal for saying that RB Health authorised, in emboldened and italicised text, RB Group to act in relation to the LTIP, or that
On
RB
behalf
Group
of,
was acting
yeah.
on behalf of RB Health when it was making the changes to the LTIP rules and imposing the PCP. Seems to me the tribunal were really just asserting those, and that's absolutely correct. It's expressed shortly, but it's correct. There is no basis for saying that there was authority in any sense relevant to agency principles. And the only basis that's put forward, and I'll come now to grapple with the point plainly and shortly, the only point put forward is to make reference to the employment contract. And it's probably worth just turning that up for a moment. So it's at tab 1 of the supplementary bundle. And what we see on page 7 is clause 5. And my learned friend argument hinges on one sentence. So the whole of that paragraph, the executive should be entitled to participate in retirement, while their benefits, incentive compensation, purposes and other plans and arrangements of the company applicable to its senior executives as an effect on such terms as are prescribed by the company in its sole direction from time to time. Such participation includes any awards granted under the long-term incentive plan of a group company. Now, what we say in relation to that is all that this clause is doing is it's setting out that the employees shall have the entitlement to participate in the various arrangements put in place by the company, and it is noting that there may be awards issued under the long-term incentive plan. What it cannot be doing is binding group to make awards, because group is not a party to the contract. At the very most, all that one could do with this clause is to say that it amounted to a procurement obligation, that health would procure group to issue awards. That would be the very most that could be said about it. But either way, it does not give rise to any sort of agency relation. And indeed, the structure of the language includes any awards granted. And that reflects the terms of the rules, of course, because the rules say nobody's got a right to any award. This is separate from your contract of employment, and the obligations only begin when you get granted an award.
As may be granted.
As may be granted. So this does not provide any authority to group to do anything, nor could it.
So if the group decided not to make any awards under the long-term incentive plan, there wouldn't be a breach.
No. If it's construed as a procurement obligation, if that's the proper construction of it, then there would only be a breach if health did not say to group, please issue an award. But no, there'd be no breach either way if group decided not to make an award. So, my lords and my lady, those are my submissions in relation to agency. Unless you have any questions, I'll then move on to the question of
Anything further?
No, thank you very much.
Okay, justification.
Justification. So I'm going to make my submissions under the following heads. First of all, our case at trial. Respondent's case at trial. Secondly, why the EAT was right to accept it. Third, why the EAT was wrong to deal with the matter in the way that they did. And then fourthly, very briefly, my grounds of appeal, which are largely parasitic.
Grounds of affirmation, really.
Grounds of affirmation, my lord, you are quite correct.
Yep. Okay, so your case at trial.
So our case at trial, and one starts obviously with section 19 2D. I don't know whether my lord, my lady needs me to turn that up again. Mr. Reid took you to it. But that is not section 19 of the...
well, let's have it open in
yes.
front of us again. Tab 12.
So it's tab 11, quite right, my lord. And it is at page 210.
Yeah.
And it is the definition of indirect discrimination.
Yes.
And it says, that a person discriminates against another if A applies to B a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic of B's. So it's only discriminatory if it satisfies all of the criteria in 2. And then first of all, PCP. Secondly, group disadvantage. Thirdly, individual disadvantage. And then crucially, D, A cannot show it to be a proportionate means of achieving a legitimate aim.
Yeah.
So we had to show at trial that the PCP was a proportionate means of achieving a legitimate aim. And our case on justification in relation to retention, we also ran a case on incentivisation, which, as you've seen, the ET did not accept.
And we're not worried about that.
We're not worried about that. But our case on retention fell under 2 heads, but they sort of
Overlap
into what they do. They're at the same point. I'll come to show you an authority where Mr. Justice Elias, as he then was, says the difference between them really is cemented. First, we said that we had a legitimate aim of retention, and that in order to retain employees, part and parcel of that was directing the retention measure towards those employees who could be retained. And the second part of the legitimate aim, which is, as I say, is largely the same point, is that we were seeking to direct and confine retention payments to existing employees, because it's only existing employees who can be retained, and otherwise you're simply providing a windfall. And my argument really was summed up. I'm just going to direct you to one passage of my written closing submissions. If it doesn't stretch your patience too far, I'll say that these were not pithy closing submissions, but they are as they are. Page 134 of the supplemental bundle. And what I do at page 133 is I've got paragraph 4, which I would describe in
133 of the supplementary bundle seems to be the rules.
Really,
Oh, I'm in the wrong bundle.
I think, well, yes, I'm on 133 of the supplemental bundle. I think that is correct.
I've got the rules at 133.
have you?
Yes.
I think, I'm sure.
Well, maybe not.
It should have paragraph 4 at the top.
No, I've got paragraph 5.1.
Right.
At 128, I've got grounds of resistance there.
I think what else gone wrong there. You can hand up a set. My lord, are you in the core bundle? Rather than
With
supplemental?
respect.
Supplementary. Oh no, I'm in the core bundle. Cancel that. Oh yes, now I'm in. Right, 134.
133. You'll see at paragraph 4 what I would describe, and Miss Banji may smile when I say this, as a general whinge about the way in which she'd approached the case and why I regarded it to miss the
Maybe you
point.
didn't put it like that.
Well, it's my whinge.
Your
rather-
whinge.
It's my whinge
I'm
rather
sure,
than.
I'm sure she didn't put it like that.
She would be too polite to express it in those terms, but it's probably a fair characteristic of it.
Yes.
So I've got my
Anyway.
whinge at paragraph 4, and then
Yes.
over the page at paragraph 6, I say, well, at paragraph 5, I say that the ET should not be sidetracked by that approach, and then at 6, I say, once the analysis is confined to these issues, the case is relatively straightforward. In short, however the statistics are formulated in this case, irrespective of the answer, the agency issue and the time issue, RB Group's approach was very obviously objectively justified and lawful. The retention and incentivisation of existing employees are obviously legitimate aims. All employers need to retain and incentivise existing employees. They cannot function otherwise. But there are two parts to the legitimate aim. One is retention and incentivisation. The other is existing employees. And how else does an employer confine its retention and incentivisation to existing employees without excluding former employees? It cannot, obviously rational, legitimate, and justified to seek to offer retention and incentivisation awards only to those existing employees who are capable of being retained and incentivised. As C rightly conceded in cross-examination, you cannot incentivise people who have already left to stay. Let me read that again. You cannot incentivise people who have already left to stay until May. So that was, I expressed there were two parts to the legitimate aim. It's about retention, but it's also about retaining particular types of employees, existing employees, and therefore directing the retention measure to those. Now, that is a submission which has echoes of submissions that have been made in other cases, and most obviously the case of Loxley, which is in the bundle of authorities that you've got. It's at tab 5 of the bundle of authorities. If we start off at 89, which is the beginning.
What's it all about?
I'm just about to tell my lord. It's a contractual redundancy payments case. And what happened under the scheme in this case was that as employees reached retirement age, there were tapering provisions. And the purpose of the tapering provisions was to prevent a situation where somebody was made redundant the year before they were due to retire, for example, received an enormous redundancy payment, and actually it was more beneficial for the employee to receive that redundancy payment than it was to work through until retirement. So those provisions were on the face of it, which depended on length of service and on age, because the tapering provisions obviously kicked in the closer you got to retirement age and therefore were age dependent. So they were prima facie discriminatory. I think in that case actually directly discriminatory rather than indirectly discriminatory. But nonetheless, the question was whether or not the scheme could be justified as a proportionate means of achieving a legitimate aim. And if one turns forward in the bundle to page 97, this is Mr. Justice Elias, as he then was, the president of the EAT, and he says, we reject the claimant's submission that preventing a windfall cannot be a legitimate feature of the scheme. one of the purposes of a redundancy scheme of this nature is to cushion workers from the effects of losing their income. This is not required, or at least not to the same extent, where pensions are paid. Indeed, if the position was still where that retirement automatically took place at the age of 60, then an employer would, in our view, manifestly be justified in having a rule which prevented the employee from being better off as a consequence of receiving redundancy pay than he would have been if working until retirement age. That is what the tapering provisions originally achieved until the extension of retirement age in 1996. This is a legitimate means of securing the aims of the scheme. Similarly, it is legitimate to seek to ensure that the aims are achieved in an equitable and fair way. Whether, and this is the key sentence, whether these are better described as aims or as proper means of achieving the aims is perhaps a matter of semantics. So really the two arguments advancing really do collapse. I mean, there are semantic differences between them, but they really are the same point. Whether you say the aims of the provision at issue was retention, and part of the means is directing the retention measure towards those who can be retained and away from those who can't, or whether one says that the directing the retention payments to, I use retention payments in a broad sense, obviously these are awards, but directing the retention measure towards only those people who could be retained is an aim in itself. They're really two sides of the same coin. That's the case that we advanced at trial, and it was a case that the tribunal accepted. And so, turning then to the ET's judgment, and I'm going to pick it up first at paragraph 112. And this is, I'm sorry, page 112.
Page, isn't it?
I'm sorry, on page 112.
Yes.
Paragraph 195. So this is under the heading retention as a legitimate aim. And this is a paragraph I took you to this morning when I was setting out in broad terms the nature of our case. But it's important to look at it again. Retention was the essence of the PCP, 3 lines down. Putting it bluntly, individuals were getting valuable awards they would not otherwise be entitled to. And in return, they were doing nothing more than remaining with the business for a particular period of time. The obligation to remain with the business for a particular period of time was reinforced by the extension of vesting to May 2020. That was the amended performance condition only applied to those who were employed at 18th of September 2019 was entirely consistent with that. Those who'd already left the business could not be retained. So there, the tribunal is accepting my submission that retention was a legitimate aim, and that part of that legitimate aim was confining the retention measures to those who could be retained. So that's where one deals with the nature of the legitimate aim. Over the page, when dealing with the question of proportionality, it's the same point, because really the question of legitimate aim and the means in this sort of argument are really one and the same point. If what you're trying to do is to encourage retention and direct your payments to those who can be retained, then you exclude those who can't be retained. And one sees my submission is recorded at 200. I said it was obvious. You can't retain staff who've already left. If your goal is retention, there must be a cut-off date, and choosing the date of the decision was a rational way of doing that. Any amendment that did not have such a cut-off date would result in the advantaging of many staff, including the claimant who'd already left and could not be retained. So that's really the windfall argument. And then at 202, the tribunal accepts that. If, as we accept it was, the aim of the PCP was retention, it must be the case that it only applies to those who were employees at the date of the change. They were the only employees who could be retained. The claimant's argument that the amended performance criteria should be applied to those who had already left but who retained rights under the LTIP scheme does not do anything for the retention of staff. So it is true to say that the tribunal accepts my submission in short form, but that's because it's a short point. You don't pay retention payments, you don't direct retention measures to people who've left because you can't retain them. They're gone. That was my submission. It was accepted by the ET, and rightly so. What the ET then went on to do is to examine some of the arguments that were put against me. And the principal argument that was put against me was in relation to the 6 employees. So there were 6 employees who'd already entered into agreements, who were leaving in one form or another. And so they were employees at the 18th of September, but they were on their way out.
If they wouldn't be there by May, they get a pro rata award, yes.
And it was said, the argument was squarely put by Miss Banerjee. She says there are these 6 employees, and those employees cannot be retained, and yet they get payments. And we had an argument about that. Miss Banerjee said that affected the proportionality of the scheme, and we said no, it didn't. And the reason why it doesn't is because you're justifying the broad scheme, the broad nature of the rule. And if the broad nature of the rule is justified, then the fact that there are people at the margins who fall on the wrong side is neither here nor there. And you can see those arguments considered. And indeed, if one looks forward to page 115, at 213, my submission is recorded. Respondents say we should not be concerned with those at the margins. 6 out of 400 original participants, of around 270 ongoing participants. So there were originally 400, but people had left. There were 270 left. And we're talking about 6. And so our submission was you should focus on, and you'll see in quotation there, the substantial majority of the people on either side of the line. And that is the reason why that is in quotation marks, is because that comes from a case called Carson, which my lord, I know, which deals with welfare benefits which were provided on an age-related basis. But there are various authorities. There's Carson, which is a public law case. There's Cochrane, a decision of this court, Lord Justice Bean, all of which say the same thing, which is you don't worry about people who fall at the margins. You worry about the broad nature of the rule. Now, Miss Banerjee's submission, by contrast, was to draw upon a decision of the EAT from Mr. Justice Eady in a case called Pitcher and the University of Oxford. And the ET then quotes that at 214 and says the appropriateness of a measure may be undermined by the inclusion of exceptions that are inconsistent with the aim in question. And that, of course, is true. That is a proposition of employment and discrimination law which finds its roots in European jurisprudence. The ET at 215 says both of these propositions are correct. And this, if I may say so, is an absolutely accurate statement of the law. Odd exceptions and anomalies do not mean that the PCP is not capable of being a proportionate means of achieving legitimate. But too many exceptions or anomalies cast doubt on whether the PCP is really in pursuance of the claimed legitimate aim or whether it is in pursuance of the claimed legitimate aim it is proportionate. Absolutely classic statement of the law. And they apply that, and they look at this case, and they say it's 6, it's a relatively small number. They say perhaps we should have looked at that, perhaps we should have carved those 6 out, perhaps we would have done if we turned our minds to it, but we didn't. And they say overall it doesn't affect the justification of the provision as a whole. That is a finding that they're entitled to reach. We would say it's plainly correct. It's certainly a finding that they're entitled to reach. And then at 217, they say, having found that respondents were pursuing a legitimate aim of retention, satisfied the PCP was a proportionate means of achieving that aim, the amended performance condition had to be subject to some sort of qualifying or cut-off date to be effective as a retention tool and to avoid unnecessary payments to those who were no longer in a position to be retained. The date of the decision was made with the most appropriate qualifying or cut-off date that could be applied, and the aim and proportionality of the PCP is not substantially undermined by the fact there was a small anomalous category of employees who benefited from the amended performance criteria, despite not being in a position to be retained. That's the reasoning. That we would say is absolutely correct as a matter of law. The right legal test is set out, and that is applied by the tribunal in a way that is not only legitimate, but we would say obviously correct in a case like this. I'll just say a word, if I might do, because it's been a refrain throughout this case to say that we didn't focus on cost. We didn't make any cost-saving argument. And that's correct. And I'll say it again if it helps. We do not rely on saving cost as a justification in this case. We never have.
No, you're not saying we've got to save money, we're in trouble. What you're saying is there's no point paying money to people we can't keep, which is slightly different.
Which is different.
The word is different,
Yeah.
217.
Absolutely. We have never said we wanted to save money. And that's obvious if one looks at what happened. If Mr. Fasano had been employed at the 18th of September, he'd have got the money. we're not saying what we had, that there was a scarce resource here and we had to divide it up and we did it on that basis. Rather, what we were saying is we wanted to pay retention payments to those who could be retained and not to those who couldn't. So that's why we say the ET judgment is right. And we do say, with respect to the learned judge who dealt with this matter in the EAT, that he got this wholly wrong. And perhaps I can now take the court to the reasoning. It begins at page 45
Yes.
of the bundle, and what the judge does at paragraph 14 is to set out paragraph 217 of the ET's judgment.
Yes.
And they say to me, and the judge says it's clear that this reasoning is deficient. The change to the performance criteria and the vesting date for the awards both contributed to the legitimate aim of retention. But it was the specific PCP and not the change as a whole that needs to be justified, as the tribunal recognised in a different context. Even if it was thought that there was a need for some sort of qualifying or cut-off date in relation to the amended performance condition, the relevant PCP could not contribute to the retention of staff. As the tribunal appeared to recognise in the first final phase of this quotation, the only real justification for the PCP was to avoid unnecessary payments to those who could not be retained, i.e. to save expenditure of money. But it was never part of the respondent's case that the legitimate aim of the PCP was to save money. They could not afford to pay the participants. Well, that's just wholly wrong. And let me break it down. First, what the judge in the EAT was doing was introducing exactly the sort of semantic distinction which was deprecated by Mr. Justice Elias in the Loxley case. What he is saying is that the limit of the case on justification was retention, and he was saying that that introducing a cut-off date does not assist with retention. So first of all, that's wrong because that is a wholly semantic distinction. It's not what we were arguing.
I can see what you're saying. If you said everybody who's in work on the 18th of September will get 50% and they could leave midnight on the 18th of September, whatever it was, then you haven't achieved anything. But is that the PCP?
Well, that's not the PCP. But even if
the scheme rules, it's not the PCP. You say.
But even if that was all that the PCP was, that would still be justified for the reason that what you're doing is in drawing that line, you are directing the payments to those who can be retained. So you're excluding those who can't be retained.
The problem is if it's 50% from past performance, and you can get it if you walk away that night.
Yes.
It looks harder to say somebody who's also done the same performance or pro-rata the same performance, who's left as opposed to going that night, shouldn't get it.
Well, this is obviously hypothetical because that's not what the PCP was, and that's not what we did. But just,
I think what the judge thought we were doing.
Well,
I think
if that's what he thought, then that's a good reason for this court not to follow that reasoning.
What do you say that the tribunal? Presumably, you challenge the tribunal's recharacterisation or characterisation of the of paragraph 217 of the ET's judgment.
Because what's an oddity in this case is that we were in the EAT on Thursday, and I think on the Monday morning we had an email from the judge in the EAT which rather foreshadowed the judgment which is ultimately given. So the judge is right to say that, I think he says at 15, Mr. Forshaw was given fair warning that I'd formed this provisional view. Well, that's true, I was. So I did come forearmed, having received that slightly unusual email. And I repeatedly told the judge that he was wrong. And you'll see then at 16, I'm afraid that however many times he repeated these arguments, I remained of the same view. So that's my reference to me not being pithy in the EAT, because I repeatedly told the judge that that he was mischaracterising the position, but nonetheless he was unmoved. And you can see, indeed, he records at paragraph 15 of his judgment. He records my submission in part. He says, I valiantly defended the tribunal's conclusion. He said that the whole purpose of the changes made by REMCO on 18th of September was to retain existing staff. Funds were entitled to direct the payments towards those who could be retained and away from those who could not. Making a payment to Mr. Fasano did not advance the aim of retaining staff and amounted in effect to a windfall for him, since if the LTIP terms had not been changed, he would receive nothing. Mr. Forshaw said that if he was wrong, his clients would not be making retention payments as they intended, but rather paying money away to people who could not be retained. So there it is.
Why does he say the last two sentences of paragraph 16 at the top of 47?
So those are, as part of the changes, they introduced a PCP which did not itself contribute to the achievement of the aim at all. It was necessary to justify the PCP, not the aim. So what he's saying there, his characterisation is that the overall changes to the scheme were directed to retention, but the cut-off date was not. But that is a mischaracterisation of, well, there are two problems with that. The first is that it's a mischaracterisation of the nature of the PCP, because what the PCP was is that you had to be in place on the 18th of September and then work through until May.
You have to be in employment in order to benefit from the amended performance condition.
Which was exactly the point my Lord Justice Lewis made this morning.
Yes, exactly right.
Yeah.
But there's an additional difficulty with it as well, which is that in any event, if all you did, now this wasn't the position, but if all you did was drew the line at 18th of September and no more, well, that would still be directed towards stopping people from gaining a windfall payment.
Yes, but it wouldn't achieve retention, he says. It's got to be a proportionate use of legitimate aim. And if you're saying you've worked hard, we'll pay you 50% and hope you'll stay, he's saying that's not enough, is what I think he's really saying. They could walk with the payment and they'll be in exactly the same position as Mr. Fasano. He's already walked with agreement and he's not getting the money for his past work. That's what I think the judge thought was happening.
He's even wrong about that. I mean, that's not the factual position, so he's wrong on the facts. But he's even wrong about that, because if what you did, you could say, for example, a company might say, right, for this group of employees that remains in employment, we're going to make a payment. And we're going to do that because that will aid retention, because happy employees who are getting paid remuneration under the scheme are more likely to stay. So we're not going to put in place the rule you've got to work through until May. We're just going to try and keep our employees happy by saying that the scheme will pay out in order to keep the employees happy, because it's always paid out in previous years, and so we're going to. And if you did that, and you said, well, we're not going to apply that same rule to employees who left. We don't need to keep them happy. They've gone. We don't need to amend the performance conditions for them. That would still be legitimate in encouraging retention and in preventing windfalls.
So looking at paragraph 40 now, at the top of page 46, as I understand it, your first criticism is that where he says it can't contribute to the retention of staff, that's wrong, because the PCP as a whole could contribute to the retention of staff because it was May 20, and in any event you say keeping people happy is more likely to make them willing to stay, but we're not in that. So that's your first criticism. Your second criticism is he has translated the unnecessary payments to those who would not be retained to saving money, and that's not what you say. You say they're not the same.
No, they're not.
So that's your two criticisms of that then.
Well, I think they end up being four in my grounds.
Oh, right, hang on.
But I'm not. Perhaps I'm not being pithy. But essentially, yes. I mean, if one turns to my grounds of appeal, I say ground one, there was no error on the face of the ET's decision, so the ET was right. It reached a conclusion applying the law correctly, and the ET could not interfere with that and should not have interfered with that. And I've not put the authorities in the bundle before you, my lords, my lady, because they're mother's milk. But cases like Hollister and Cleveland Glass, it's not for the EAT to interfere with the decision made by the ET unless an error of law is demonstrated. There was no error of law on the face of the decision. Indeed, we would say that ET reached the only conclusion that was reasonably open to it on the facts. Secondly, the EAT was wrong to find that the means adopted did not contribute to the aims relied on. So that's the point, my lord, that you've just made. thirdly, we say they misstated the legitimate aims because they didn't recognise that part of the legitimate aim that we're relying on was not just retention in itself, but retention measures directed towards existing employees so that they could be retained and to avoid windfalls. And fourth, we say, even if we're wrong about all of that, the idea that this was a case which the EAT should have substituted its view instead of directing it back to the Employment Tribunal, we say is quite wrong.
Right.
So those are my submissions on the justification issue. I've not directed the court to Kraft Foods and Hasty, which is another windfall case, but the relevant passage is highlighted, and I'll invite the court to look at that when you deliberate. Might I turn my back for a moment?
Thank you very much, Mr. Ford.
Just turning back, he asked.
No, thank you. Thank you. Thank you very much, Mr. Ford. Yes, Mr. Reed.
Thank you very much. Well, I'll deal, if I may, firstly with the agency point. I'm not going to rehearse my previous arguments, obviously. What I want to do is just focus attention, and for convenience, it's probably best if I focus attention where we deal with this in the skeleton argument. And it's page 208 of the core bundle. And by way of response, of course, my little friend took you through the authority,
Yes.
and the line of the authority in relation to the powers to create the LTIP arrangements. I don't question that, of course. The authority was derived from the board, approved from the shareholders, to make grants and to define the particular rules. But what he's doing is deflecting your attention from the actual focus that had to be applied in looking at this claim, which was the relationship between the employer, or rather the former employer, and Mr. Fasano. When you focus upon that, what you recognise, and I'm taking you to this section so we can see where we link it back to the tribunal's findings, is that we're concerned with the benefits which are being conferred upon Mr. Fasano, not with the authority that creates or confers them, but how those come to happen. And that rests in the relationship between him and his former employer, Health. There is no contractual relationship between him and Group, a point my learned friend has made. And of course, when one thinks about the analogy of comparison with strangers, in legal terms, Group is a stranger to that extent, because although there are obligations within his contract about duties that may be embraced with Group, actually, when it comes to the employment relationship, it's only looking at the particular relationship with his employer. That's why we say, and 38 really encapsulates it, why it is so distinct from the examples that my learned friend relies upon. The waitress in Khmer in the MOD office. We can the three points which are identified here. So Group were acting on behalf of Health in providing the benefit. It was providing a benefit for Health's employee. That's a key point. Health had benefits that it provided in the sense of wages, bonus, but another key benefit of the wage bargain was that which is being provided. Now, my learned friend says, well, that's where you might have an independent contractor point, but that's one of the clear findings the tribunal make, cross-reflecting it back to paragraph 146. Second thing, assent. Now, we say it's clear they've made a finding about assent. My Lord Justice Lewis says, well, the structure of ET judgments has findings in structure and conclusions. I mean, that line isn't always as clearly drawn in circumstances where they've looked at an entire analysis. But what we can see is an ongoing employment relationship with Mr. Fasano until the point where he departs, in the context of which his employer Health has seen him have benefits provided by Group. And looking at that, the tribunal make their finding, we say, that's 38.2, that Health had assented to Group acting on its behalf to provide those benefits.
And Group had assented to Health.
Sorry.
Group head ascended to act on health's behalf.
Sorry. Yes, I do
But
apologise. Yes. So
are you coming on to that, or are you dealing with that at the same point?
it's the same point that health as a centred a group acting on its behalf in providing LTIPs for its employees, and that's 148.
And
I've already
including
taken you to
providing
define.
benefits for people who aren't its employees. On your case, it's not just assented to providing benefits for employees. They've authorised, RB Health has authorised them to make benefit payments for non-employees, and you say they did that by authorising the first set of rules under which changes could be made, and if they made them, they had to make them for past employees as well as future ones. That's what you say.
Well, I don't say they had to make them for past employees as opposed to future. They had to make them lawfully, and if they didn't make them lawfully but discriminated in doing it, then I say that health are liable for it.
On what basis did they find? Did they find? They seem to have found. On what basis was there a finding that group had ascended to act on health's behalf?
Well, I say it's one that they found the structure that existed, that there was a contractual relationship between Fasano, Mr. Fasano, and his employer, including a discretion for the provision of benefits. But what's happened, and their findings in the earlier part make it clear, is that through that process, LTIPs have been provided by group. It was always open, because that was a discretion, for health to have put its own arrangements in place. I mean, there would have been purposeless, no doubt, because it wasn't a traded share, but it had a discretion to provide its own separate benefits. What it's clearly chosen to do, by the passage of time, one can see it happening, is have a structure where it has that benefit provided by group for its employees. And that's where the assent comes from, a course of conduct, which you can see starting off with the employment relationship that provides that discretion, but more importantly, the structure. And the tribunal's earlier findings find that structure in place. The employees of health had the benefit, the senior employees of health had the benefit of LTIPs which have been granted by group. And health wasn't putting a separate structure in place. It was for its employees accepting that particular position. And really, there's that fundamental proposition that my learned friend has to gloss over, that because of the fact that group has no employees, the only purpose, effectively, well, except for two, the only purpose in doing this exercise was to confer benefits for the benefit of health and co-employers. And then the third finding, taking these together, is that what group was doing impacted upon the legal relationship between Mr. Fasano and health. And that's found at paragraph 149 of the Employment Tribunal's rules, because of course what they were doing is 149 of the Employment Tribunal decision, what they were doing is changing the nature of benefits and arrangements. Now, it doesn't matter later on that we're looking at something that is an ex-employee. What matters is the structure that's been put in place when he was a current employee. Because if you looked when he was a current employee at his package of arrangements, you'd say, well, there's your salary, there's the bonus that health is paying you, and there is an LTIP structure that is being provided for you, employee, health employee, by a structure that exists at group level. That's why those three things together we point to as leading to a conclusion the tribunal is entitled to conclude that for the purposes of the common law, this was an agency relationship. Now, we've obviously referred, and below, at first instance, an argument was advanced about the purposeful interpretation. I take Lord Justice Lewis's point, but one thing that must be noted in relation to that is what the ET actually found. This is at page 46 in the forerunner.
46.
Oh, I do apologise. I've taken you to the EAT.
You have.
146. I'm sorry. I mean page 104. I'm sorry, paragraph 150.
Yes.
This is the conclusion of the agency reasoning, and obviously that's what we're supporting. But if you look at paragraph 150 on page 104, what the ET conclude is that the scheme is being offered by the first respondent to the second respondent's agent for the second respondent. As noted above, we draw this conclusion from the common law definition of agency, comma. So the tribunal isn't deciding it on the basis of a purposeful interpretation of the legislation or an application. The tribunal is quite clearly deciding it on the basis of the facts which I've identified on their drawing and the application of common law principles. Now, it's true, they go on to say, but it also seems to us this must be the right conclusion if a properly purposeful approach is taken to the definition of agency. Well, that's belt and braces. They haven't departed from the primary conclusion, which stands as an analysis of law. So I say, in response to my learned friend in relation to agency, fine, we can look at authority. Fine, we can look at the autonomy of that, but let's look at the factual findings of the tribunal, which are what are critical in relation to the determination in relation to this case. And the tribunal were right in their particular approach. Justification. Coming back to justification, my learned friend took you to Loxley.
Yes.
Of course, when one looks at justification, one has to be careful about the aim that is being justified. So, in Loxley, the aim that was being justified was the approach to redundancy payments, the terms of their redundancy payment arrangements. And if you just turn it up, that's at page 80. The case begins at page 89, and the passage my learned friend took you to is at paragraph
37.
Yes, page 107.
97.
I'm sorry, 97. Yes,
Para 37.
correct. And if you look at the beginning, is that when they're identifying the purposes, Lord Justice Elias is identifying the purposes of the scheme. He says this: one of the purposes of the redundancy scheme of this nature is to cushion workers from the effects of losing their income. Now, when you realise that's the aim of the scheme,
One of the aim.
one of the aims of the schemes, one could understand why tapering the scheme as you got closer to retirement was a proportionate aim, was a proportionate means of achieving that aim, because you had a situation where individuals would be entitled to pension and would not be continuing their earning entitlement after normal retirement. So that's why the scheme tapered down towards the retirement age. There'd been a change.
Yes.
So viewed in the context of the aim, phrases about windfall are unhelpful. The reason that there was tapering is to reflect nothing to do with windfall, but to deal with the fact that what one's doing is a very specific exercise by way of aim.
Well, the sentence you referred to follows on from a sentence in which the tribunal EAT rejected the claimant's submission that preventing a windfall cannot be a legitimate feature of the scheme. So that was that sentence.
Yes. Well, I think
It follows on from that, doesn't it?
Well, I think my learned friend elevates that into a proposition to say that it's always a legitimate aim to avoid a windfall. What I'm suggesting is that that sentence has to be read in the context of the remainder to see that it might have been viewed that it was a windfall in that particular case to pay it on top of the pension, but actually the underlying rationale behind that sentence, beginning with one of the purposes, makes it clear that the tapering was achieving the aim. It's not the windfall point, it's the tapering achieving the aim of cushioning when seen against the existence of a retirement age and pension provision coming in.
I wonder whether windfall is in fact an unhelpful word. And by windfall, what we mean is a payment to which a person is not contractually entitled. And what has happened here, so Mr. Forshaw says, is that a retired employee was not contractually entitled to the 50% benefits. When they decided they wanted to keep people in work, they didn't allocate money to pay 50%, i.e. to make a payment to which the person concerned was not contractually entitled and which would not encourage him to stay in work because he'd already gone.
Well, so firstly, the language of windfall is very much the language of the respondents in relation to this.
Therefore, I'm not blaming you, it's him, yes.
And obviously we think we agree that it's potentially misleading to use the language of windfall, because where one starts from, even if one talks about that, none of the employees, whether former employees who were good leavers or in employment, at the 19th of September, before a change in relation to the strike rules, had any value in the LTIPs at all. It was zero. So,
Yes.
So everyone was in the same place.
Nobody was having a windfall.
No one was getting anything.
Nobody was having, well,
No one's
the
getting anything.
contractual payments that they were entitled were worth nothing because the performance condition has been met.
That's
So
exactly
what
right.
happened afterwards is that some people were given money, 50% of what they would have got under the performance award, but they had to be working. Whereas those who weren't working and didn't have a contractual entitlement of 50% didn't get it. That's all that I think is meant by windfall in this case.
Yes, and then when we focus on that, I think it's helpful just to, and obviously we essentially say, and I'm not repeating it, that what the EAT concluded at paragraph 6 about the rationale for this stands about it not achieving the requirement to be in work at that 19th of September 2019, not achieving the aim is right. And I think one can make that point clearly if one approaches the PCP slightly differently. If you look at page 98 of the core bundle, the section my learned friend took you to, just so you know, this is the minutes of the meeting of the Remuneration Committee on the 18th of September, and he took you to those.
Do you mean the supplementary?
I'm sorry?
Do you mean the supplementary one?
Oh, I do apologise.
said
I
the
mean the
core.
supplementary. I'm sorry.
Oh, right. 98.
98.
Yes, that's right. This is where
Uh,
we were.
So he took you to the section that begins after due and careful consideration. It
Yes.
is accordingly resolved that the committee consents to the performance conditions attached to 2019. Now, pause for the moment, ignore for the moment the square brackets. Held by all participants who are currently group employees at the 18th of September and who are not executive directors of the company. Ignore that for the moment and read in respect of both share awards and options being amended pursuant to 1.4 of the Reckitt Benckiser Group Long-Term Incentive Plan, with effect from the 18th of September, such that, and as my learned friend rightly pointed out, that what it means then is that the criteria is 50%, even if the performance is low. Now, the reason I ignored the bracket is what's in the brackets about the condition of being in employment on the 18th of September is that because of the scheme rules, if you ignore that 18th of September wording, you still achieve the legitimate aim of retention, because the scheme rules, nothing changed about this, meant even if you had the performance criteria waived, you had to be in employment at May 2020, or you had to have been a good leaver. That was all written. Nothing was changed about that in relation to the rules. So they would achieve the aim of incentivising retention by their workforce simply by that. that's why we say, and this is why the PCP, and I appreciate the observation that the PCP has found includes the retention to May 2020, but that's why we say the critical aspect of it is that introducing the condition of employment on the 18th of September didn't achieve retention, because that was achieved just by removing the performance condition. What it achieved is whether you style it as being saving money, as my learned friend says that wasn't the concern, or whether you simply style it as being, well, we didn't want to pay it to ex-employees, that doesn't matter. It's not achieving the aim. And what the EAT are absolutely, we respectfully say, right about is that you can't achieve a case that you carry the burden upon of showing that there's a proportionate means of achieving a legitimate aim unless your PCP is achieving that aim. And that discriminatory aspect of which is the thing that bites, so far as Mr. Fasano is concerned, of being on employment of the 18th of September, does not achieve the aim. It may satisfy them that they're not paying money to people who are former employees, but it doesn't achieve the aim of retention. And once, as we respectfully say, you realise that, as the EAT pointed out, we say with great clarity in the passage at paragraph 16, actually, and my learned friend touched on this briefly, it's right that the EAT not only could conclude that the tribunal had erred in law on justification, because they had focused on the wrong thing. They'd looked at the whole scheme aim, ignoring what needed to be justified. But actually, once you realise there's an error of law, it's one of those obvious cases where the EAT was entitled to substitute a conclusion.
The difference again is that people who are actually in employment, they would only be, as you call them, good leavers after the 18th of September if the company agreed to them leaving. That would be a further control. They didn't have to agree. Mr. Fasano has been allowed to leave on early retirement when his entitlement was naught. And what you're saying now is because he was allowed to leave on retirement when he wouldn't get any money from it, when they change it to try and say you've got to be working and you've got to be there at the end of May, you're saying he should get the benefit of that even though he's not an employee, and you're almost building in or assuming that he would be in the same position, that they would have agreed to him being an early leaver after September.
Well,
You equate the two situations, don't you?
well, can I firstly just respond to the first point, which is it's not just a question of their consent, because my learned friend took you to, and I don't need to, the conditions at paragraph 6, because there are factors such as ill health, injury, or permanent disability.
That isn't your client's case, is it? I thought he was agreed with the company that he could have early retirement. I hadn't realised he'd retired for ill health.
No. We're confusing two things. So I thought, it's my fault. I thought you were referring to the fact about people leaving after the 18th of September. And I think I understood you to say it was that the company had the control.
In cases like Mr. Fasano's, yes.
Well, yeah. If we're talking about situations such as Mr. Fasano, where there's an agreed termination and an agreement that the company confers that they're good leaver status, I agree. Then that's the company has that control. I think I misunderstood your point, but it doesn't change, I say, the proposition that if we're looking at the aim, whether the company's got that discretion or not of motivating people to remain, was achieved just by waiving the performance criteria, because that was the thing that had deprived all employees of any continued value in the LTIP if they remained in employment. That's why removing that was achieving the aim, but adding the caveat of employment on the particular date wasn't achieving the aim. It was doing something which, whether or not the company might have wanted to do, because it preferred not to have former employees who were good leavers have that particular entitlement, wasn't achieving the aim. And obviously, my learned friend referred to the fact, and I don't go back at it, but I do say that when you look at that aim, quite aside from proportionality, the fact that the aim of retention could have been achieved by quite simply putting in place a different structure, so a specific payment of bonus to employees, or a new LTIP scheme that wouldn't have included Mr. Fasano, he'd have no complaint about it, only serves to emphasise that what they chose to do, which was amend an existing scheme that impacted on rights that he had and treated him differently from others, albeit I acknowledge some who were in employment, who were on garden leave, and others who were at that point in time hadn't given notice, is where the disparate effect comes into play, and that's where the justification has to arise. I wonder if I might have one moment. Thank you very much. Thank you. That's all. That unless I can assist you further. In
No,
relation to
thank you very much, Mr. Reid. We're going to reserve our judgments in this case. We're very grateful to everybody who's contributed, to you, Mr. Reid, assisted by Miss Banerjee, and to you, Mr. Forshaw, and to those who sit behind you for their hard work on this case. Well prepared bundles, clarity in submissions, finished right on time. What more could we ask? Reserving our judgments, as we said. In due course, you will get a draft of our judgments. That is to provide you with an opportunity to correct any typographical or minor factual errors, obviously not to re-argue the case. You'll bear in mind, of course, the warning at the top of the draft judgment about the confidentiality. It's confined to those who are entitled to see it, and any unauthorised disclosure is a contempt of court. We'd be grateful when you submit any written typographical corrections if you would also draft a written order reflecting our decision, insofar as there are any ancillary issues on costs or anything else that may follow from our judgment. We will reserve those in writing. If you're not in agreement, we'd be grateful if you would submit short written submissions setting out your respective cases on those subsidiary issues. Thank you very much.
Rise the table.